Welcome, everybody. Excited to have you in class today. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center. We're really excited to have you in class today. Today's class is going to dive deep into the 14th Amendment and incorporation. So we have a lot to cover today, really exciting topic. And to do all this great work, we're here with our top scholar, Tom Donnelly from the National Constitution Center. So Tom, the 14th Amendment is like really your jam, right? This is your thing, you love it, you deep dive into it all the time, right?
Absolutely.
With so much enthusiasm. Okay, so Tom, as we dive into this and kind of break it out, what I love about this class and how you've broken it down for our students is the 14th Amendment can feel really overwhelming. And we're going to read the words in a minute. And it is the amendment that I go back to. I know every single word, but I feel like I have to reread it constantly because you just find so much nuance and understanding. Each time you look at a case, you look at it again. But you broke it down to kind of these four big areas, these four big features. So as we dive into that, some of our guiding questions for today's class is, let's look at the Constitution and what does the 14th Amendment say? Looking at the core principles that it adds to the United States Constitution, and then how did it transform the United States Constitution? How does it promote equality? How does it promote freedom? And then how do we see the 14th Amendment today and in the courts, and even in the courts this year, and how is it being utilized, understood? And as one of our professors, Tamika Brown-Nagel, who should be coming to class very soon, said that the 14th Amendment is one of these amendments that each generation gets to understand and dive into for themselves and their own. So before we dive into the words of the Constitution, can you give us a little, how I love timelines, a foundational setting of when was the 14th Amendment added? And then what was it added with? It comes as like a little bundle of amendments at the end of the Civil War. So give us a little frame of reference of time period and what was happening during this time period. And then we'll dive into the actual words of the 14th.
Sure. So the 14th Amendment is part of this amazing series of transformational amendments that we ratify after the Civil War, the 13th, 14th, 15th Amendments. We call these the Reconstruction Amendments because this is the period of Reconstruction that happens after the Civil War. And that generation really was trying to reconstruct America. These amendments were about putting America on firmer constitutional ground than it was on before the Civil War. And so these three amendments are really important to that. The 13th Amendment was ratified in 1865. It abolished slavery. The 14th Amendment, which we're covering today, was ratified in 1868, and it wrote the Declaration of Independence's promise of freedom and equality into the Constitution. And the 15th Amendment, ratified in 1870, banned racial discrimination in voting. But again, all of these amendments together were all about setting a better constitutional foundation for America. It's why many scholars, both on the left and the right, refer to this key period and these amendments as part of America's second founding.
And we started off, if students were in the pregame show, where we just asked Tom questions, we started talking about this period of time. And, our students have gotten questions where they're asked by their teachers, okay, write an essay. Was Reconstruction a failure or a success? But can you tell us kind of some of the amazing experiments in interracial democracy that was going on during this time and give us this moment in time and a little snapshot?
Yeah, absolutely. I mean, so Reconstruction is this amazing moment that's both powerful, transformational, but far too brief. And so this is a period in which America really tried for the first time to make multiracial democracy work. And it really did for a period of this time. During this period, we saw African Americans meeting in conventions throughout the nation, meeting with one another, trying to say, what is it that we need in America to make it live up to the Declaration of Independence's promise? What do we need to be full and equal citizens? We saw African Americans voting in massive numbers, electing Republicans throughout the South and pushing for the ratification of the 14th and 15th Amendments. And we also see African Americans holding office at all levels of government, US senators, US House members, governors, state legislators, all the way down to key positions in local governments like sheriffs and justices of the peace throughout the South. And then we also saw a national government for a time acting to protect the constitutional rights of all. But of course, the flip side of this is, Curry, is that we know that this moment was too brief. We know that the Supreme Court during this period, especially in the 1870s, 1880s, and into the 1890s, would read the protections of the 14th Amendment, but all of the Reconstruction amendments fairly narrowly. And we'd also see the sort of the reemergence of white Southern rules throughout the South, which brought with it the Jim Crow system of segregation, which was a mix of laws, intimidation, and violence that really imposed second-class citizenship on African Americans. And so that's sort of the two sides of this period. Reconstruction initially beginning of this rebirth of America, but then a push back in the other direction and a push towards Jim Crow that would require generations upon generations thereafter to fight back against, defeat Jim Crow, and reaffirm the promise of the Reconstruction amendments that we put into the Constitution right after the Civil War. So
amazing triumphs and tragedy as you look at this over 150 years. So the Reconstruction time period, that brief, when we talk about a brief period, what is it, 1865 to 1877?
That's contested. That's the tradition. That's the traditional period. But really, if we're talking about what is the period of like a great activity at the national level, passing big laws and constitutional amendments, it's even briefer than that. It's really like 1865 to, I would say until like 1871, 72. That's where the most of the action's happening. But then state by state, we have massive African-American political participation that lasts many, many years beyond that.
Great, got it. Just to, box it.
Yeah, because again, the African-American political participation story runs past 1877. So it's longer than that. But again, still far too brief.
Awesome. Thank you for that kind of framing and base. And then we think of this moment in time, in Reconstruction time period, adding the 14th Amendment, and that leads us perfectly to the words of the 14th Amendment. I might actually make this just a tad bit bigger to make sure everybody can jam their face really closely to their screen as you kind of read through and tell us why everything's so color-coded. It's not just for fun.
Yeah, no, this is a big wall of text, but it's so important that it's worth reading at the beginning so we have it ringing in our ears. This is Section 1 of the 14th Amendment. Here goes. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This first sentence is known as the Citizenship Clause. And then we have a second sentence here which contains three different important clauses. Here we go. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That's the Privileges or Immunities Clause. The next part is, nor shall any state deprive any person of life, liberty, or property without due process of law. That's the Due Process Clause. Nor deny to any person within its jurisdiction the equal protection of the laws. That's the Equal Protection Clause.
Awesome. And I remember first diving into this and realizing all these clauses are put in there. But just to really quickly walk everybody through, there is a Section 2, a Section 3, a Section 4, and a Section 5. We're going to really focus on Section 1 and Section 5 today, but we really do encourage you to read through all of them. And we will send out at the end of the week a little 6-minute video where Eric Foner breaks down every single section very quickly, but it's fantastic. Tom, do you want to make a kind of a nod to Section 5 and then we'll go into the features?
Yeah, so Section 5, this is an important part that gives powers to Congress. It says that Congress shall have the power to enforce by appropriate legislation the provisions of this article. Part of this is ensuring that both Section 1 and Section 5 work together to promote all of the key protections throughout the 14th Amendment. It means that if you're looking to realize the promise of the 14th Amendment, you can turn to both the courts and Congress to realize those protections.
Oh, and I love that because that's going to come so into play as we get through this conversation today, the courts and Congress, we the people in lots of different avenues. So starting with the natural born citizenship, we look at these 4 big features. And I love that you point out that this one is really kind of like an envelope around the other 3. So you have these guarantees in the 14th Amendment, and then here you go. Here's, the carrot and the stick. Here's the stick to actually get that work done. Now, the question is, does Congress use it? But can you break down each one of these and how the connection to the clauses, but what do they really mean by birthright citizenship?
Absolutely. So these are the 4 big features of the 14th Amendment, the 4 ways in which the 14th Amendment transforms the Constitution forever. The first one is birthright citizenship. And here the big idea is that Dred Scott v. Sandford is overturned. African Americans do have rights that the white man is bound to respect. And if you're born on American soil, you're an American citizen. In many ways, this was the Reconstruction generation speaking back to the Supreme Court that decided Dred Scott v. Sandford, the case that said African Americans can't be citizens and that, quote, had no rights which the white man was bound to respect. The Reconstruction generation here is saying, no, Supreme Court, no, Chief Justice Taney, no Dred Scott decision, you're wrong. So that's birthright citizenship. The second big idea is equality. And so the thing to remember here is that the original Constitution is largely silent on the issue of equality. And so with the 14th Amendment, we now write the Declaration of Independence's promise of equality into the Constitution. It's now in the text and a key part of the debates that would go forward over what the Constitution means. So that's birthright citizenship, equality. The next big feature is freedom. And so with freedom, the important thing to remember is that the original Bill of Rights, which gives us the freedom of speech, religious liberty of the press, jury rights, all of these key protections, for many of us, what we take the Constitution really to be, that original Bill of Rights only applied to abuses by the national government, not to the states. It's with the 14th Amendment that we then take those protections and begin to apply them to state abuses. And so through the 14th Amendment, the Bill of Rights itself becomes a genuine charter of national freedom that applies as much to the national government as to the states. So that's birthright citizenship, equality, freedom. The last key point is national power over civil rights. That's Section 5 of the 14th Amendment. This is where Congress is now given the power to enforce the protections enshrined in the 14th Amendment. The Reconstruction Amendments, the 13th, 14th, and 15th are the first set of amendments to expand the reach of national power. So the national government has more power than it did before. And here, the key thing is that it has power to enforce these key protections in the Reconstruction Amendments. This doesn't solve the problem or sort of debates over federalism. From then to today, we continue to debate how much power goes to the national government, how much power goes to the states. But the 14th Amendment and the Reconstruction Amendments as a whole rebalance that power so much, giving the national government more power and more responsibility than it had before.
And again, I love Tom citing evidence of why they call it the second founding. Just so, as you heard him say earlier, some scholars call it the second founding, more power to Congress, and really like rewriting and changing that dynamic in these three, each one of these, the 13th, the 14th, and the 15th, all has this national power given to Congress, correct?
Yes, absolutely.
Okay, now before we jump into each one of them, so what we're going to do is look at each one of these big features, dive in, and then walk through the timeline around the courts of what has happened and how the people have pushed for change or how that section has been pulled back. Before we dive into that, let's give a minute to John Bingham. And why should we know who John Bingham is and what should we know about him?
Yeah, so John Bingham, he's a forgotten founder. He was a representative from Ohio in the US House. But for our purposes, his most important legacy is that he was the primary author of Section 1 of the 14th Amendment. That big block of text we read at the beginning, he was responsible for much of it. And he was also the driving force of that vision of bringing new powers to check the abuses of the states. When the states limit our freedoms, when they attack equality, John Bingham thought that the national government and the courts should be able to step in and protect our most fundamental rights and to ensure that all of us are treated equally. The great Justice Hugo Black, a justice in the 20th century, referred to John Bingham as the 14th Amendment's James Madison. And I think in many ways, that's the best way to think about him.
Awesome. And I do love that. We know James Madison so well. Let's make sure we all know John Bingham just as well. And I love this quote that you've pulled for us, and I absolutely love it. Simple, strong, plain declaration that equal laws and equal and exact justice shall hereafter be secured within every state of the union. It's just such a powerful statement in words. And really, when you're looking at what does the 14th Amendment mean and what does Section 1 mean, you can go right back to his words.
That's exactly right. That's John Bingham on the campaign trail in 1866, both fighting for the 14th Amendment and fighting for his own reelection.
Awesome. Oh, that's so cool. Thank you, Tom. Okay, now let's dive in. Let's dive into each of those big areas. And let's begin with birthright citizenship. And this brings us to, one of a very sad story, but such a heroic story of Harriet and Dred Scott. So this is before the 14th Amendment, before the Civil War. Give us kind of that walkthrough of what happened with Harriet and Dred Scott. and then the timeline that really happens around this part of the 14th Amendment.
So yeah, Dred Scott v. Sandford, it's 1857, so it's just a few years before the Civil War. It involves Dred and Harriet Scott. They're an enslaved couple, and what they're doing is they're coming to courts arguing for their freedom. They said that they were taken to free soil, and then because of that, they should be given their freedom. They should no longer be enslaved. And so their case works all the way through the court system, works its way to the Supreme Court, and the Supreme Court ultimately says, no, Harriet and Dred Scott, you're wrong. It's an opinion by Chief Justice Roger Brooke Taney, and he says two big things that are relevant to the Citizenship Clause of the 14th Amendment. He says, one, African Americans can't be United States citizens, and two, African Americans had no rights which the white man was bound to respect. And then what we see afterwards, though, is that this is a highly controversial opinion. So Justice Benjamin Curtis, who's one of the dissenters in the case, he resigns from the Supreme Court in protest over the Dred Scott decision. For Abraham Lincoln and the new Republican Party, one of their rallying cries is that Dred Scott is wrongly decided, that we need to reverse the Dred Scott decision. And ultimately, after the Civil War is over and after we write the 13th Amendment into the Constitution to abolish slavery, with the 14th Amendment, again, that first sentence, the Citizenship Clause, is all about that Reconstruction generation saying, Harriet and Dred Scott, you were right. Supreme Court Chief Justice Taney, you were wrong. And that ultimately here, if you're born on American soil, you're a United States citizen. And Curry, what we see is by the end of the 1800s, we see one really important case on the Citizenship Clause, which involved, it's called United States versus Wong Kim Ark. So Wong Kim Ark he's a Chinese American. He is born in California. His parents are Chinese citizens. And what happens in this case is that Wong Kim Ark's parents return to China. And so, you know, like a good child, he wants to visit his parents. He goes back to China, visits his parents, then he travels back to the United States, tries to get back in, and the United States officials say, no, you cannot come back into the United States. You are not a United States citizen. Wong Kim Ark says, what are you talking about? I was born in California. I've read my 14th Amendment. By being born in California, I am an American citizen, and of course I can come back in. And so this case works its way all the way up to the Supreme Court. And in a 6-2 decision by Justice Horace Gray, the Supreme Court says, Wong Kim Ark, you're right. Government officials, you're wrong. And so what the court says here, they give a pretty broad reading of the Citizenship Clause. And the key point, though, is that for the Supreme Court in Wong Kim Ark, they say, under the 14th Amendment, it doesn't matter who your parents were. It doesn't matter, Wong Kim Ark, that your parents were Chinese citizens. It matters where you were born. You were born here on American soil. That makes you an American citizen. That's what the 14th Amendment is all about. There are some exceptions to this. Say if you're the child of a diplomat or of a Native American tribe that does not have American citizenship, you're subject to some legal immunities, and because of that, you might not be a United States citizen. The key language in the Citizenship Clause is subject to the jurisdiction thereof. But the broader point is that's a very narrow exception to a very broad rule that the Supreme Court reads into the Citizenship Clause, that if you're born on American soil, you're an American citizen. Again, it's a 6-2 decision. So there were two dissenters, Curry, and people have debated this language from that point all the way to today. But in Wong Kim Ark, the Supreme Court sets an important precedent about the meaning of the Citizenship Clause.
Awesome. So Dred Scott decision, the constitutional amendment of the 14th Amendment overturns that part of the Dred Scott decision. And then the Wong Kim Ark is really the test, and the courts lay down the precedent and say, here's where we're sitting with this. Now, the next section that we look at is equal protection of equality. And then we'll move on to protection of freedom. And Mohammed asked a question, when you start to dive into due process, which I know will come in the next two sections, can you really explain to him, what does due process of the law mean? So just want to add that as you jump in here and have your dive into that. So looking at protection of equality, we look at the 14th Amendment, but we also look at how the 14th Amendment was set up, what was its original meaning, and then how did the courts pull it back or roll it back?
Yeah, so you read the quote from John Bingham. That's a good idea of what at least one of the framers of the 14th Amendment had to think, what had to think about the 14th Amendment's promise of equality. What we see is as we get into the late 1800s, we see the Supreme Court read this protection of equality narrowly. And the key case there is Plessy v. Ferguson, which involved a law in Louisiana that separated white passengers from African Americans on rail cars in Louisiana. And there was a challenge to this by Homer Plessy, saying that a law like that, of course, it violates the 14th Amendment. It violates the 14th Amendment's promise of equality. And the Supreme Court said, Plessy, you're wrong. Actually, this is consistent with the 14th Amendment. States can impose this form of segregation. It's consistent with the state's powers to promote the health, safety, and welfare of their citizens. So that's the Supreme Court in Plessy v. Ferguson saying separate but equal is okay. You could provide separate facilities to African Americans and white Americans, and that's okay. There's a powerful dissent, we don't have time to get into it, by Justice John Marshall Harlan in Plessy v. Ferguson saying, what in the world are you talking about, majority? Of course this violates equality. But Plessy remained good law from 1896 until Brown versus Board of Education in 1954. So all through those years, we see this system of Jim Crow segregation develop in restaurants, in hotels, but also in schools. And so Brown versus Board of Education is all about this little girl, Linda Brown, a third grader, and her parents challenging the system of segregation in the schools and Plessy v. Ferguson itself. And so their argument is simple. It's much like Homer Plessy's argument, which is what can be more clearly a violation of equal protection of the laws than separating white students from African American students. But this time the Supreme Court, in a unanimous decision authored by Chief Justice Earl Warren, said, Linda Brown, you're right. You are right. The court for Plessy, they were wrong. Plessy was wrong the day it was decided. School segregation violates the 14th Amendment's promise of equality. Here's the key language from Chief Justice Warren. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. What Warren's saying is that it doesn't matter if you have separate and equal facilities. They were never equal, but even if they were, the very act of separating out white students from African American students that brands the African American students with a feeling of inferiority, and it promotes second-class citizenship for African Americans. Of course, that violates the 14th Amendment.
Awesome. And it's such a powerful story. And Tom, I love the way that you tell it. Now we're going to dive really quickly, and we got 8 minutes left, but little side turn to women's and gender equality. And Sally asked in the chat earlier about, do we need an ERA if we have the 14th Amendment? It harkened to so many times that Akil has talked about that, but I thought it would also give you an opportunity to answer that as you kind of walk us through the fight for gender equality and the 14th Amendment.
Yeah, so right after the 14th Amendment, 15th Amendment are ratified, which group is one of the first groups to lay claim to it? It's women's rights activists. It's women fighting for things like the right to practice law in a case called Bradwell versus Illinois, and also for the right to vote in a case called Minor v. Happersett. So women at the very beginning are saying, look, the Equal Protection Clause, it speaks of any person. It's not just, it applies to discrimination based on sex. And so they tried to lay claim to it, but the Supreme Court rejects these arguments in cases, again, Bradwell versus Illinois, Minor v. Happersett. To give a flavor of how the court is thinking about this, there's an infamous concurrence by Justice Joseph Bradley where he says in the Bradwell decision, in his concurrence in Bradwell, the paramount destiny and mission of women are to fill the noble and benign offices of wife and mother. This is the law of the Creator. And so here in the early days, the 14th Amendment is not read to extend many protections to women, but a century later, finally, women lay claim to the 14th Amendment and win before the Supreme Court. And the main architect of this legal strategy is a lawyer you may have heard of. It's Ruth Bader Ginsburg. Before she's a justice, she wins a series of important decisions in the 1970s before the Supreme Court, which expand the 14th Amendment's Equal Protection Clause to cover sex discrimination. And finally, as a Supreme Court justice in 1996, she authors a landmark decision, Virginia versus United States, where the Supreme Court rules that Virginia Military Academy's male-only admissions policy violates the Equal Protection Clause. She says that if a state is going to discriminate on the basis of sex, it needs an exceedingly persuasive justification. It needs a really, 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 really good reason to do that. And so with that, she says, sex classifications may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women. So we see the Equal Protection Clause taking on women and providing genuine protections. And you're right, there are debates now over, is the 14th Amendment itself with the Equal Protection Clause enough? Or do we need those additional protections that might be provided by the Equal Rights Amendments? And that's where the advocates and the opponents of the amendment, they come out differently on that question.
Awesome. Fantastic. Okay, we're rolling now. Protection of freedom and diving into what is incorporation?
Yeah, incorporate. So the promise of freedom here that we're talking about, it has especially to do with the expansion of various rights protections against state abuses. So incorporation, remember, so the key point here is that, the key thing to remember is that the original Bill of Rights only applies to the national government. It's through the 14th Amendment and decisions of the Supreme Court in the 20th century that we expand many of those protections in the Bill of Rights to cover state abuses. That process of thinking right by right about whether it should apply to state abuses is known as incorporation. It's where, so I'm in New Jersey right now. It's because of incorporation where if the governor or the state legislature violates my free speech rights, I can now use the First Amendment and the 14th Amendment to challenge that in courts and declare it unconstitutional. That wasn't the case before incorporation, but it is now. And so with incorporation, the Bill of Rights becomes a genuine charter of national freedom, applying as much to the national government as it does to state and local governments. It applies to all levels of government because for the Reconstruction generation, John Bingham and those that wrote the 14th Amendment, one of the key lessons of American history was that not only should we be skeptical of the national government and its power and its potential for abuse, but that states also had the potential to abuse. They had just seceded. They had just imposed the institution of slavery throughout an entire region. And so for that generation, it was important to also protect the liberties of all Americans against those incursions by the states. But Curry, it was a process. It was a process over time. Oh, I'm sorry, Carrie, yes.
Oh, no. I thought it would be perfect here to bring in Muhammad's and David's question, because Muhammad wanted to understand this process. And the two students asked the great question. So Muhammad wanted to understand how this process went through the due process clause and what does that mean? And then David wanted to understand, could you see this incorporation through other sections like privileges and immunities, and wanted to know a little bit more about the slaughterhouse case. So I think it would give you a great opportunity to go both ways on that.
Yeah, absolutely. So yeah, I'll do it I'll touch it historically and sort of get to both of those. So I mean, the key thing is in 1833, there's a key case, Barron versus Baltimore, where Chief Justice Marshall confirms that the Bill of Rights only applies to the national government. It doesn't apply to the states. Then we have the ratification of the 14th Amendment in 1868. And there's a lot of evidence around the text and history of the 14th Amendment that part of what it was supposed to accomplish was something like incorporation. Maybe not exactly, but something like incorporation. And if you were to ask John Bingham, I would guess if he was sitting next to me, he would say incorporation would probably happen under the Privileges or Immunities Clause. It's the most natural fit for something like incorporation. But in the first big case about the 14th Amendment in 1873, the slaughterhouse cases, the Supreme Court ultimately reads the Privileges or Immunities Clause really, really narrowly, effectively does all but write it out of the Constitution. And so as it will take decades upon decades until the court returns to this question of incorporation and takes it up. It's really the first big incorporation case where this project begins in earnest isn't really until 1925. So it's a really long period of time after Slaughterhouse, Gitlow versus New York. And at that point, the Supreme Court, it has a choice. It could overturn the slaughterhouse cases and use the Privileges or Immunities Clause, but instead it chooses to use the Due Process Clause of the 14th Amendment. What the court has said over time is that clause protects, on the one hand, things like procedure and process. So that's due process of law in that sense. It's being treated fairly by the government in different proceedings. Fair, like a notice to be heard, a fair opportunity to make your arguments, things like that. That's known as procedural due process. But the court also says that within the Due Process Clause, there's something known as substantive due process, which this is where we read due process protecting certain liberties, like liberties in the Bill of Rights, or even some rights that aren't written specifically in the Constitution. Today, we'd say something like the right to privacy. You know, back in the late 1800s, they see something like economic liberty. But these are two ways in which the court has used the 14th Amendment to promote freedom. And so I really don't want to get too caught up on jargon or which clause of the Constitution it is. The court does incorporation under the Due Process Clause. It started that in Gitlow. It did it then all the way up until just a couple of years ago, where it's still incorporating rights in the Bill of Rights through this process of incorporation. But the broader thing to understand is that the 14th Amendment is promoting a certain vision of freedom and a certain vision that's checking abuses by the states. It's important that the 14th Amendment in Section 1, one of the key phrases is no state shall. It's specifically meant as a check on the states. And so what we say from beginning in Gitlow in 1925, but especially picking up in the 1950s and 60s and beyond, is this process of what legal scholars call selective incorporation, where different challengers are coming to the court saying this right in the Bill of Rights, whether it's free speech, free press, religious liberty, protection against unreasonable searches and seizures, or cruel and unusual punishments, you name it, litigants are coming to court saying, you need to incorporate this right against the states. You need to apply this protection in the Bill of Rights against the states. And the trend is that right after right, the court has said yes. So now virtually every key protection in the Bill of Rights is incorporated against the states. Virtually every right in the Bill of Rights protects you against state abuses. There are only really three that have not been incorporated yet. The Third Amendment's protection against the quartering of soldiers, the Fifth Amendment's grand jury right, the Seventh Amendment civil jury right. But what's kind of amazing, Curry, is that this process has continued over the last decade or last 12 years. We saw the incorporation of the Second Amendment's individual right to keep and bear arms, and the Eighth Amendment's ban on excessive fines, and the protection for a unanimous jury verdict. All of that has just happened in the last few years. So the incorporation revolution in that sense has continued.
Awesome. Okay, one last part, which is a really big part, is Congress is now given more power, that last feature. And I think it's interesting to kind of end with this because we talk so much in this class about these court cases and people bringing these questions to the court and the court deciding either to pull back or to push forward and expand the right or to restrict it and read it thinly. But there also people can actually make this change too, and Congress can change the laws from the requests of people through Congress. So can you talk a little bit about Congress having more power and then maybe the Civil Rights Act and the Voting Rights Act?
Yeah, so I mean, it was very important to the Reconstruction generation to empower Congress. Because remember, for them, when they think of like which institution's acting well and which is acting poorly, they would think we're Congress. We're the members of Congress. We are doing the right thing after the Civil War. The Supreme Court is the Supreme Court of Dred Scott. We think of the Dred Scott decision. So we want to make sure that we're not leaving all of these questions to the courts. We want to make sure that we clearly give Congress the power to do things that promote the protections in the 14th Amendment as well. And so, yeah, Curry, you're right. If we just think of like, so we left off in the story of equality with Brown versus Board of Education in 1954, what we see is another decade of resistance to the Brown decision. And so we see many Southern school districts resisting desegregation, still either closing down schools or trying to still separate white students from African-American students. This was known as the period of massive resistance to Brown. But furthermore, we also know that it took decades upon decades of advocacy on the ground, protests, marches, all the things the civil rights movement was doing, and then also lobbying of Congress to write even stronger protections into the law and ensure that we really are living up to the Constitution's promise of freedom and equality. In this context, the two key laws are the Civil Rights Act of 1964, which expands equality to a variety of settings from the workplace to schools to restaurants to you name it. It's a very broad protection of equality. The Supreme Court would then uphold this act in a case called Heart of Atlanta. So there you see sort of the Supreme Court acts, then a new piece of legislation happens and the Supreme Court says, yeah, no, that's consistent with the Constitution. And we see the same thing in the context of voting rights. With the Voting Rights Act of 1965, the court again provides new strong protections for African-American voting rights. It really works. We see a massive expansion of African-American voter participation, African-American office holding. We see just the dismantling of the pervasive system of Jim Crow laws in the voting context. So the Voting Rights Act, it's strong constitutional medicine. But again, in a case called South Carolina versus Katzenbach, shortly thereafter, the Supreme Court, in an opinion by Chief Justice Earl Warren, would say the Voting Rights Act may be strong constitutional medicine, but it's necessary after decades upon decades of state laws that have flouted the broad promise of the 15th Amendment's protection of voting rights for African Americans and the 14th Amendment's broad promise of freedom and equality.
And we have the ending of the poll tax too, as a constitutional amendment change. That's 1964 or 65.
The poll tax might even be 61. It's somewhere in the early 60s.
We'll look it up.
I don't know it off the top of my head. I'm sorry, Curry.
No, I was like, oh, I can't remember the last number. But I think it's really fascinating to see, looking at this equal protection. You have the push from the people through Congress, from the people through the courts, and then from the people to the entire system to change the Constitution. And I love that. You know, it's a multi-strategy attack, and you see that so well with the civil rights movement, that they are doing this work on every single level of the system and a strategy over decades across the country. So fascinating. This is why we love talking about the 14th Amendment. We are totally out of time, but it is the amendment that we can constantly keep an eye on as we're looking at new court cases coming out of the courts, because it's almost very often referenced. But Tom, you said something earlier about why is it so important to not just look at the opinions, but the dissents in these modern cases?
Yeah, I mean, so many of these cases touch on issues that we care about. They touch on big questions about the role of Congress, the role and powers of Congress, the role and powers of the states, and the role and powers of the courts. And so many of the Supreme Court decisions end up having powerful majority opinions, powerful dissents, and often they will be strong opinions that can really give you a sense of the contours of the debates, give you a better sense of which side you think has the Constitution right, but also allow you to understand some of the arguments behind those that you might disagree with. Because these are really, really hard. A lot of these are really, really hard questions, especially as we get into modern questions that often address, either how broadly the promise of freedom sweeps, how broadly the promise of equality sweeps, and ends up touching on so many of the issues that we care most about everything from abortion to religious liberty to free speech to affirmative action to equality to basically anything you could possibly imagine.
Awesome. Fantastic. Thank you so much, Tom. Appreciate it so much. And students, we're going to wrap up now, but if you have any questions, we will hang out because I know a few of you did, so I'll add them in. So let me stop the recording. Stop share. 1964. I was like,
yes, I saw it in my interactive constitution.
Oh, you're good. Colin looked it up for me.